اللهم صل وسلم على سيدنا ومولانا محمد. اللهم صل وسلم على سيدنا ومولانا محمد عدد ما بعلم الله صلاة دائمة بدوام ملك الله، صلاة دائمة بدوام ملك الله.
Ya Allah, Tuhanku memberikan berkat atas semua Nabi-Nabi kita dari Adam sampai Nuh, lalu Ibrahim, Musa dan Ruh Allah Isa alaihi salam, terus ke Nabi Daud dan Sulaiman, Nabi Zakaria, Yahya dan Shu'aib. Jangan kita pernah lupa atau lalai bersyukur dan ingat Nabi-Nabi Allah. Salawat atas mereka semua, atas Nabi-Nabi yang kita kenal dan atas mereka yang belum kita tahu. Semuanya membawa pesan, dan tanpa itu kita enggak kenal Tuhan. Mereka adalah abangnya Ahmad, Nabi yang terakhir, Nabi Muhammad.
صل وسلم على سيدنا ومولانا محمد عدد ما بعلم الله صلاة دائمة بدوام ملك الله صلاة دائمة بدوام ملك الله.
Ya Allah, Tuhanku memberikan berkat atas semua Nabi-Nabi kita dari Adam sampai Nuh, yeah. Lalu Ibrahim, Musa dan Ruh Allah Isa alaihi salam. Terus ke Nabi Daud dan Sulaiman, Nabi Zakaria, Yahya dan Shu'aib. Jangan kita pernah lupa atau lalai bersyukur dan ingat Nabi-Nabi Allah. Salawat atas mereka semua, atas Nabi-Nabi yang kita kenal dan atas mereka yang belum kita tahu. Semuanya membawa pesan, dan tanpa itu kita enggak kenal Tuhan. Mereka adalah abangnya Ahmad, Nabi yang terakhir, Nabi Muhammad.
أيها الأحبة في الله السلام عليكم ورحمة الله وبركاته. A very good morning to all the listeners of the Al-Ikhlaas Academia Library here from the Islamia School in Cape Town. With us in studio today we have the respected and honorable Sheikh Dr. Muneer Abduroaf. This morning's session is basically a continuation and part 2 of the first session, which dealt with the importance of Islamic wills within the South African context. Welcome, Sheikh Muneer, and it's an absolute pleasure to have you with us here today.
Wa alaikum salam wa rahmatullahi wa barakatuh, and shukran for having me here this morning.
Absolute pleasure. Dear listeners, before we commence, inshallah, with this morning's discussion, a short biography of Dr. Muneer Abduroaf. Dr. Muneer Abduroaf is a senior law lecturer at the University of the Western Cape, Department of Private Law, where he lectures in the laws of succession, family law, Muslim personal law, and Islamic law and jurisprudence. He is both an admitted attorney and a sworn translator of the High Court of South Africa. He is also a marriage officer for the Department of Home Affairs. He has also been appointed as a CRL Rights Commissioner by the President of South Africa to promote and protect cultural, religious, and linguistic rights. The CRL Rights Commission is a Chapter 9 institution. Dr. Muneer Abduroaf has obtained an LLD law degree, which is a doctorate in constitutional theory, a master's law degree in transnational justice, a bachelor's law degree in South African law, and a bachelor's law degree in Sharia law during his academic career. He is also a member of the Muslim Judicial Council Fatwa Committee and sits as an ad hoc judge at the Sharia court at the council. Dr. Muneer Abduroaf's professional association includes being an imam at Masjid al-Rauf in Highlands Estate, an assistant editor for the Manchester Journal of Transnational Islamic Law and Practice, a commissioner for the Commission for the Cultural, Religious and Linguistic Rights, which is the CRL Rights Commission, a member of the International Network of Scholars Researching Unregistered Marriages, a member of the Muslim Judicial Council South Africa, and a member of the Islamic Business Compliance Authority. MashaAllah, as we can see, Sheikh Muneer Abduroaf is quite an expert in the field. He was recently overseas as well, attending a conference in Belgium.
Alhamdulillah.
MashaAllah. Perhaps you can tell us a little bit more about your trip, your recent trip to Belgium.
Shukran Qari Nadeem for that introduction as well. The trip in Belgium was more to do with family law within the international community. So I've presented a paper there on the recognition of marriages concluded in terms of Islamic law, Islamic marriages within the South African context. And alhamdulillah, the paper was quite well received, and many other family law experts around the globe at least have presented at the conference. So alhamdulillah, hopefully many papers will flow therefrom.
MashaAllah, that's excellent. And in terms of the audience that was being addressed, was it a public audience? Was it an academic audience? And you mentioned that one of the matters of discussion was basically with reference to Islamic wills within the Muslim community here in South Africa. And is it perhaps that they are looking at South Africa as a case study, given that Belgium also has a Muslim minority?
Yeah, basically the attendees were academics from, I think, was it 50 odd countries around the globe. And yeah, definitely one of the focus areas was the application of the religious rights within Muslim minority countries. And yeah, within the session that I presented it, that was basically one of the key aspects. Be it succession law, or be it family law, or marriage law, and all of these things, it basically touches on succession or inheritance. Because if the marriage is recognized, then automatically entitled to inherit. But if the marriage is not recognized, then it becomes quite problematic.
Alhamdulillah, excellent. Alhamdulillah. We wish you well, inshallah, in your
Ameen.
future travels, and we ask Allah Azza wa Jal that He continue to utilize you and accept your efforts. I know you have been quite passionate and quite active in the community over many, many years when it comes to Islamic estates, wills, succession planning, inheritance, and the wills clinics that you regularly have in and around Cape Town. MashaAllah, an excellent effort, and I think much needed, a huge shortfall within our communities. In fact, the stats being in the profession as well, the stats indicate that actually 3 in 4 South Africans pass away without having a valid will. So it's basically 25% of the population only in general that leave behind a valid will. Sheikh Muneer, could you perhaps, for the benefit of the audience, before we get a little more in-depth into the discussion, just take us through the notion of, we often hear about an Islamic will, we often hear of people saying that I want an Islamic will, or I've left behind an Islamic will and I want my estate to be dealt with in terms of Sharia law. Could you explain to the audience what is an Islamic will?
Yeah, shukran for that question. So basically an Islamic will is, within the South African context at least, it deals with ensuring that all provisions and directives given by a person making the will, the testator, ensuring that those provisions are in terms of Islamic law. So in South Africa we find there's something referred to as freedom of testation, right? So you can do with your will, with your estate at least, whatever you want, as long as it does not go against public morals, contra bono mores. Right? So generally you can do what you want. And also it has to be constitutional. It cannot be violating any of the constitutional rights. So once you have done that, you have looked at what the Quran says, you have looked at what the Sunnah of the Prophet ﷺ says, you have ensured that, for example, all your creditors are seen to, your religious liabilities as well. You have made use of the bequest, the wasiyyah, and those wasiyyah bequests are also compliant with Sharia law.
Sure.
It's not something which is haram. It does not exceed what is allowed for a Muslim to bequeath and so forth. And it's not given to persons who are not entitled to inherit from the wasiyyah and so forth.
Yes.
Right? So then that would be an Islamic will as far as the wasiyyah is concerned. Also then stating that the remainder or residue of the estate should be distributed as per Quranic injunction in terms of the Quran or the Sunnah, or stating there who inherits, but ensuring that it is in line with the Quran and the Sunnah. Once all of that has been done, then a will of that nature could be deemed or referred to as an Islamic will.
Alhamdulillah, shukran for that explanation. You also touched on the notion of wasiyyah, or the construct of wasiyyah, and I think we will get into that shortly. But in terms of the recognition now, Sheikh, of a Muslim will or an Islamic will, within the South African context, what happens if a person passes away with an Islamic will?
All right, so
or having a will which was an Islamic will?
Yeah. So there are two ways in looking at an Islamic will. The first way would be where the will directs in detail as to who should inherit, the son's names, the daughter's names, and all of that. The second way is with regard to the will stating that all the religious liabilities should be seen to, all the creditors must be paid whatever they're entitled to. The wasiyyah is also stipulated, but for the residue of the estate, it doesn't state who the beneficiaries are. And the reason for this would be because it might be the person is married to someone today, but he might be married to another a lady tomorrow, which would be a polygynous marriage, or he might have had a divorce. You might also have a situation where there's one child today when drafting and executing the will,
Yes.
but when he passes away, he might have had 5 or 6 children. So the time when drafting and executing the will, right, it might have been Sharia compliant or an Islamic will, but at the time of his death, at that point in time was no longer a Sharia will, or Sharia compliant will. So let's look at the first situation. First situation, he says, look here, right, that I leave it according to Sharia. Right.
Sure.
That in that instance, it is much more safer, as the Islamic will, after directing the liabilities, after directing the wasiyyah, it then leaves it up to the executor of the estate to then go to an Islamic institution like the Muslim Judicial Council, SA here in Cape Town, or any other jamiat in South Africa, that would then draft and issue an Islamic distribution certificate, and stating at that point in time, when the person died, who his lawful beneficiaries were in terms of Islamic law. So the will, either stipulating all the beneficiaries already from outset, or the will that requires an Islamic distribution certificate. Both instances, these wills must then be lodged with the Master of the High Court. The Master of the High Court would have to accept the will as valid wills, and also being the last will of the deceased. Because it might also be that the person has a will drafted and executed today, but it might be down the line 2 or 3 years later, he drafts another will. So that later will could possibly cancel and revoke the previous will. Right? The Master of the High Court will then oversee the whole process. After accepting the last will and testament, it's a valid will, and the executor of the estate should then administer the estate based on South African law principles of having the liquidation distribution account drafted and so forth, published in the local newspapers, government gazette.
Yes.
And once the process has been followed, and the master then says that, all right, now you can go ahead and distribute, that is when the beneficiaries will now receive what they are entitled to in terms of the Islamic will.
Sure. Sheikh, so you, with regard to the Islamic distribution certificate, as you're aware, there are various processes that need to take place and various documents that need to be completed before the application can be lodged with the Master of the High Court. Now, at what point in time would a family member or someone liable to inherit approach the Jamiat to obtain the distribution certificate before? Would it be at the outset after someone has passed away? Would the Jamiat then have regard to the will that was left behind and consider it before they can basically make recommendation in terms of the distribution allowance? Or at what point in time would one get the Jamia or an organization like the MJC per se involved?
Yeah, a very important question, yeah, and it would happen basically as soon as the person passes away. The beneficiaries would want to have the whatever they're entitled to as far as the distribution is concerned. But in reality, it might be a house, it might be an asset that is tied somewhere. So the master should actually give the final approval as to how it should be distributed. If the will doesn't state who the beneficiaries are, it would mean that that certificate issued by the Jamiat or the Muslim Judicial Council in the Western Cape, for example, is required before lodging it with the Master of the High Court. And at that point in time, the institution would then require where's the marriage certificate to prove as that they were married, Islamic marriage or civil marriage, but Islamic marriage is the one that is recognized for the Islamic institution. Where are the birth certificates of these persons? They would also require an affidavit confirming that these are the only children and there are no other children as far as this estate is concerned. And those documentation would be submitted to the institution. The institution then issues the Islamic distribution certificate sooner rather than later. And then both these documentation would then be submitted to the master, and thereafter there is also a whole process that must then follow thereafter.
In terms of average timelines, what can one expect in terms of the total and complete wounding up of an estate, provided one has all the correct documentation in place?
Yeah, it would depend on how complicated the estate is. Anything from 6, 7, 8 months up to 2 years. Sure. Depending on whether or not there is any discrepancies in the estate, assets that require a sale of a house and the the beneficiaries can't come to an agreement as to whether we will sell the house or keep the house, or there are a number of complications that could arise. It might be the house has not been paid off, and so forth. But anything from a few months up to years, depending on whether or not also the beneficiaries and how complicated the estate is.
A common scenario we frequently come across is where the deceased left behind a property, usually one or two properties, with multiple people that are entitled to inherit. And we often see this becoming a problem, and it basically leads to a long, lengthy, drawn-out process up until the time when the estate is basically wound up. And for the reasons that you rightfully pointed out, where the beneficiaries are often not all on the same page in terms of the decision as to whether the house should be sold or whether it should be kept. Can a house be transferred to multiple beneficiaries in terms of ownership, perhaps in terms of a percentage? Or must it be that the house would now need to be sold? And often you find that there are still some of the beneficiaries. There recently was a matter where a person had two wives, and during his lifetime he occupied the house with the one wife, and the other wife would receive an allowance which allowed her to rent an alternative residence. But now that he had passed away, there was a claim from the other side with the children of the other wife as well. What would be the best advice in a scenario such as this?
A situation of that nature is quite complex, and if you're looking at the Islamic distribution certificate, it might state there is a surviving spouse. Let's say it is a widow. You are 3 sons and 3 daughters, which means that the widow would inherit the 1/8, and the 7/8 share between the 3 sons, 3 daughters, in the proportion of 2:1. Yeah. But now we have one asset, which is now the house.
Yes.
So how do we deal with the house? The reality is that they all own a specific share of the house, a certain fraction of the house. So either, yes, we can do that, they can have it transferred onto all their names in proportional shares, and see how that works out. But then who stays in the house? Who pays for the rates? Who pays for the maintenance of the house, and so forth? Or alternatively, what they could do is they can sit in a meeting and come to an agreement, as maybe one person buys out the house, or maybe 2 of us, we become co-owners of the house and we pay the others out, and then we use this as an investment, because then we rent the house out and we're getting our money back in this regard. Sure. So there are a number of possibilities that could take effect. Or the parties could even say that, look here, but the mother is still alive, or our mother is still alive, the widow of the deceased. Look here, it's registered in all our names, but let us remain there until she passes away. Sure. And then once she passes away, then we sort these things out. Sure. In the meantime, we all just contribute towards the rates and whatever maintenance might be required. Sure. So there's no hard and fast rule. It's a matter of conversation. Definitely. But if they don't converse, and then it becomes very complicated, and then there will be no forward moving in that regard. Conversation,
I think the operative word being conversation, and that would be the first point of duty or responsibility in terms of the executors advising the beneficiaries correctly, so that there is proper and there is reasonable and there is constructive communication. Sheikh, so the converse would then be the consequence of passing away without a valid will.
In the instance of a person passing away without an Islamic will that's also valid, would be that the South African law of intestate succession would find application. So there was an act of parliament that came into operation, or basically there was enacted in 1987, right? And in that Act 81 of 1987, referred to as the Intestate Succession Act. Now this act then deals with how the estate would then devolve in the event where a person passes away without a will. The consequences of that is quite different to what the the Sharia will would state. Because
Sure.
the Sharia will, we're looking at the Islamic institution like the Jamiat or the Muslim Judicial Council, SA, and they will base it on Islamic principles. What does verse number 11 of chapter 4 say concerning the position of parents and children? What does verse number 12 say concerning surviving spouse and uterine siblings? What does
Sure.
verse number 176 say concerning full siblings and consanguine siblings? And so
Yes.
forth. Act 81 of 1987 looks at it differently. They're looking at what the rights of a surviving spouse would be as far as this is concerned. Initially, right, it looked at if the estate is less than 125,000 rand, everything goes to the surviving spouse. Subsequent to that, the amount was then increased. If the estate is less than 250,000
That's
rand,
right.
everything goes to the surviving spouse. But if the estate is more than 250,000 rand, then we're looking at the amount of spouses as well as descendants. And we add it
Yes.
together, we divide it by the value of the estate, or the net value of the estate. If that amount is less than 250,000 rand, then we give the surviving spouse or spouses the full 250,000 rand.
Yes.
If it is more than 250,000 rand, we give them that share, which is also referred to as a child share.
Is that a proportionate share divided, added and divided by the number of people entitled to benefit, or does it differ in terms of percentage-wise?
Yeah. So if you're looking at the amount of children, for example, let's say the person passes away with 3 children,
Yeah.
right? Be it sons or daughters, we don't discriminate, and 1 wife. So that would be the widow plus 3. So it's 4. So if the estate is worth 4 million, the net estate, we're saying that now it is 4 million divided by 4, which leaves 1 million, which means that 1 million is more than 250,000 rand.
Sure.
So therefore we give her the 1 million, and the 3 million is shared between the 3 children equally. That's 1 million each, which is quite different to what the Quran says
Sure.
regarding the 1/8 and the 2:1 with regard to the remainder. What was also quite problematic in the past, even though that is not Sharia compliant, they initially, the laws of Africa initially did not recognize a surviving spouse in terms of an Islamic marriage. So you married in terms of Islamic law, that marriage was not regarded to be a marriage that would be recognized for purposes of the Act. And in a High Court judgment, it's also referred to in the thesis, Dalians versus Campbell, where one of the spouses, or basically the surviving spouse, then challenged the constitutionality of that piece of legislation and says, the mere fact that you're not recognizing my Islamic marriage, and there's no piece of legislation, there's no Muslim Marriages Act, for example, and I don't want to get married in terms of the Marriage Act or in terms of the Civil Union Act today or the Recognition of Customary Marriages Act, and I've decided then just to have my Islamic marriage, but you're not recognizing it.
Yes.
And that is unconstitutional. You're discriminating against me based on my marriage. And the court then found that, and an outcome of that case, the High Court case initially, what ended up in the Constitutional Court, was that the surviving spouse was now recognized. A few years later, we had the case, the same question that popped up in a polygynous marriage in Hassan versus Jacobs. But the difference here is that, okay, right, and then they recognized both spouses. They gave some relief in terms of the Intestate Succession Act. But the problem is that the relief that was granted is not the same relief what would have been in terms of the Islamic will based on Islamic principles. So therefore, it is quite a conundrum we're sitting in, recognizing the Islamic marriages, but not giving consequences in terms of Islamic law.
So would the case of Daniels versus Campbell find application or find reference in a situation where, for example, a Muslim wife was married to her husband in terms of Islamic rights? There were children born of the marriage, yet the husband died intestate.
Yeah, in that case, definitely the interpretation of that section in the Act based on Daniels versus Campbell would be that she would be entitled. Like in my instance, I'm married to my wife. So if I were to pass away, then she would be entitled to inherit if I pass away without a will. And the point of citation would be Daniels versus Campbell. However, in my instance, I'm also married civilly, so that recognition is there in terms of the Marriage Act as well. But any person, yes, that's not married in terms of the civil law, their recognition would either base in a monogamous marriage based on Daniels versus Campbell, or alternatively in a polygynous marriage, Hassan versus Jacobs.
Excellent, alhamdulillah. Shukran and thank you for that. I think we have about 5 minutes left, listeners. And before we conclude, a very, very important point, a key point that we often hear, the word wasiyyah, and the notion and the construct of it in terms of Quranic law. What does it mean? How much is a person allowed to basically bequeath? And how would one go about it in terms of the provision for it within an Islamic will?
Yeah, shukran for that, Qari Nadeem. A very important question concerning the wasiyyah, the bequest. Now, within the Islamic will, you'll find that there are different sections of the will. The one section deals with liabilities. So we sort out all of the religious liabilities, the creditors, and janazah expenses, funeral costs, and so forth. Thereafter, let's say the person passed away, leaving behind the 4 million. 1 million went towards the creditors and liabilities and so forth. Now we're sitting with 3 million. From the 3 million, you can bequeath up to a maximum of 1/3 of that. So in this instance, the 3 million, you can bequeath 1 million in favor of any person that does not automatically inherit in terms of the laws of inheritance, right, as per Quranic injunction. So for example, you have a child that you have looked after for his whole life. You have even adopted that child, but in terms of Sharia, the child will not inherit. So you can bequeath something to him or to her. It could be you want to bequeath something in favor of a child that was conceived out of wedlock or born out of wedlock for that case. Right? That can be done in terms of the 1 million rand. You can, for example, here for academia library, it does so much good. Right? You can bequeath something in their favor. So any person that does not automatically inherit, you can make use of that wasiyyah in order to favor those persons once you have passed on. It could also be in the form of a sadaqah jariyah, something that would continue once you have gone on. But also important to note that if your estate is quite small, right, do not give the whole wasiyyah out, then you are going to deprive your other beneficiaries, and as per Quranic injunction, from inheriting a better share.
Sure.
And the Prophet ﷺ advised that you can bequeath 1/3, but 1/3 is a lot. But to rather leave a bigger estate to your beneficiaries would be better than having to beg by people.
An excellent point, and the hadith of the Rasul ﷺ where he said that it is better for you to leave your family in a better position financially, and therefore the importance of adequate estate planning or financial planning. And I think there's a huge gap within the Muslim community in terms of the provision. We often hear the phrase, or people accept the position as in we leave it to Allah. So whilst tawakkul is important, I think the importance, this hadith sort of reinforces, more so in today, where we live in a highly capitalistic world, and everything revolves around economics.
Yeah, definitely. If you're looking at the laws of inheritance, it only finds application once a person passes away. And then obviously you can't say, when I pass away, I'm unhappy with that law. So that is not allowed at all. But while you are alive, you can gift, you can make use of the wasiyyah, you can do whatever you want as long as it is within the bound of Sharia. Sure. You can give your son a house, a daughter a house, you can give whatever you want, as long as you are fair and just between your children. Right? But once a person passes away, it's only at that point in time that the Sharia laws of inheritance find application. And that is why I think it's very important, as you just stated now, to have adequate estate planning and advice concerning what options are available and what is suited best for
Yes.
you in your circumstances.
Something very common that we witness, and it's a good point that you touched on, we often witness a general inequality between children where it concerns male children and female children, where we notice that very, very often it is the sons that are often entrusted with the family business, with the estate of the family. The daughters are married off, and within the life of the parents, or of the father in particular, if he is the one that is basically the king of the empire, where the sons would be, even in the lifetime of simply because the Quranic law is that once you do pass away, the son would receive a share that is double that of the girl. Is that how things ought to be within the life of the parents as well?
Yeah, obviously, while you're alive, then the laws of inheritance doesn't find application. That's a very big misconception as well. I see many people coming to me with their wills or their estates, and they're saying that I want to sort out everything now already. I'm giving then they ask how much inheritance is due to this one and how much inheritance is due to that one. I want to give it to them now. And I say to them, no, use the money, go to Makkah, go on Hajj, go on holiday. It's your money, right? The laws of inheritance only find application once you pass away. Then you have to say you are happy with it, and that is what Allah had decreed. As far as while you are alive, then there's no laws of inheritance, but there's laws of being fair and just
Equality,
between your children, yes. So there are so many hadith of the Prophet ﷺ where the one person gives the one child and not the other child. And the Prophet ﷺ in one instance says, I will not be a witness to something like this. Right? So yes, the laws of inheritance has its play, how it works. And as far as the laws of equality between children, we look at the time of Nabi Yusuf as well, what happened when the children could see that the father is giving preferential treatment in their eyes over some children and not the others. So definitely that is something we should stay as far as possible.
And I think these things sort of lead way to, often we find disputes arising at the time of the death or one or both of the parents. And I think it's the parents that basically have this responsibility for them to ensure during their lifetime that they foster and they create that level of fairness and equity between the children, so that there is you don't sort of prepare them or set the scene for disputes to arise later on, where one child feels that they have gotten the shorter end of the stick.
And therefore, in conclusion with that point, it's so very important and something we don't put in a will really, because Sharia has been put out already, but as advice to the children in an instance of this nature. And that is a document referred to as a wish document. And you can give them advice. So look here, right, that when you pass away, this is the house, this is the business, this is this is that. However, in my limited understanding and me knowing you as your father or mother, this is what I would like you to do, or to consider when deciding how you're going to go about either selling the business or keeping the business or selling this house or whatever it might be. And I think it will work. But however, if for some reason after having a discussion and looking at my wishes, you can't come to a solution to the matter, then just let Islamic law find application. So it's some guidance from a parent, but also stating that it's not binding. It's only binding if you all agree to it. So that is also something which would be under that estate planning as a separate document that could be used, an unenforceable wish list.
Alhamdulillah, barakallah feek. And as Allah Azza wa Jal says, there's always wisdom in His words and what has been divinely ordained, when He says, Wallahu ya'lamu wa antum la ta'lamun. He knows and we do not know. That brings us to the end of our series, Sheikh Muneer, on the importance of an Islamic will within the South African context. We just take the opportunity to thank the listeners for their attention, and we hope that you found this presentation helpful. I, for one, surely did find it extremely informative, and thank you very much for availing yourself. Barakallahu feek. Assalamu alaikum wa rahmatullahi wa barakatuh.
Wa alaikum salam wa rahmatullahi wa barakatuh.